welcome to Crime in Court. My name is Heather, and this is part 2 of the Canton 9 saga that we started on last time. If you have been keeping up with this series, the Canton Cover-Up, Commonwealth versus Karen Reed. It's easy for me to say that, huh? Anyways, so we left off last time where I gave you basically the background of everything that happened, kind of how it played out. I showed you that video that I made where Mello called in the police to the police station and wanted these people reported. Hold on, this is like right in my eyes. All right, so he wanted these people reported, the 9 very peaceful protesters, and he did. He reported them, and the police went there, and they basically intimidated them with the threat of arrest and prosecution for doing nothing other than exercising their First Amendment right. So we talked about that all in the first part. So if you missed that, definitely go watch part 1. This is part 2. We're going to continue on with Turtle Boy's daily blogs, anything that had reference to do with the Canton 9 or the freedom of speech, because that's what's really at stake here. In his blogs, I put them together, and we're just kind of reading through them now. So this one was November 26th. So remember, it happened on November, what was it? The 5th, I think. So yeah, so we are about less than 20 days away from when the incident happened, and the police were sent and sent there to intimidate peaceful, law-abiding citizens. So on November 5, 9 law-abiding citizens gathered peacefully across the street from D&E Pizza in Canton, which is owned by Canton Selectman Chris Albert, and also, quote, a witness of of the John O'Keefe case. All right, so the protesters were threatened with arrest by 4 Canton police officers who came with a printout of the MGL Chapter 268, Section 13A. We should know by now that that is for witness intimidation, which they claim that the protesters were in violation of. Officer Robert Zeff initially told the protesters that they were in violation of the law because they were within eyesight of Chris Albert, but later admitted to the protesters on the video. You saw on the video, and we went through that last time, that the woman, one of the women that was there, showed him, she's like, where does it say eyesight? I don't see anything about eyesight. And then he was looking, and he's like, oh, you're 100% correct that it was not there. So he conceded that it wasn't in the statute at all about eyesight, even though he repeated it multiple times, saying you can't be within eyesight. Anyways, eyesight of a witness. Whatever. Okay. So Zeff told them that their protest was in violation of 13A because they were across the street from a witness to a, quote, criminal crime, which is a little redundant, as Turtle Boy pointed out in one of his blogs already. They were within eyeshot of Chris Albert. Chris Albert is a witness because he testified in front of a grand jury at some point in time, even though that grand jury in the Karen Reed case has ended over a year ago, and he is no longer a witness in that regard. See, exactly. So when does your witness status end, buddy? Are you a witness until the end of time? It doesn't work that way. The content of their signs was what made their okay, so the content of their signs was what made their protest illegal, because it had language relating to the Karen Reed case and stating Colin Albert was in the house. That's what it was. He didn't like that because that's his son. So he got pissed, and he called his little cop buddies and said, get rid of these protesters. All right, so allegedly, I don't know, I wasn't there, but I'm assuming. All right, so he could not determine what the protesters were intending to do. And in the statute, it clearly states there must be intent to willfully make someone change their testimony or whatnot, whatever. So intending, he could not determine what the protesters were intending to do, yet he was accusing them of being in violation of a law that specifically requires that police show the intent of the accused. Exactly. Despite the fact that the Canton police admitted on video that the protesters were not in violation of 13A, at least 4 of the Canton 9 have received summonses to appear. I believe they all did by the end of this. That at least 4 of the 9 have received summonses to appear in the Stoughton District Court for a clerk magistrate's hearing because CPD has filed a criminal complaint against them. These charges include not only the 13A picketing and the witness statute, but also charges for violation of the much more serious 13B felony witness statute. Again, I want to repeat, they are being charged as felons for picketing, for expressing their First Amendment rights in this country. And they're going to be labeled as felons for the rest of their lives. So this is a summons. And this is just one, but several of them received the same summons. And I'll read it as best I can. Actually, you know what? There's 2 pictured, so I'll read this one because it's easier to read. All right, so up here, 268 13A, 268 13BA. So court, judge, juror, picketing, witness, juror, police, court official, intimidate. So that's what the Canton 9 are now being charged with, is witness intimidation and picketing a witness. So stupid. Okay, so to the parties to this complaint application, you are hereby notified that the above named complainant has filed an application for criminal complaint against the above named defendant and has requested a hearing by a judicial officer of this court. The number of offense counts charges presented in this criminal complaint application are shown in the no counts box above, and the first 4 offense counts are listed above, whatever that means. If there are more than 4, why do they have to be so confusing? If there are more than 4 offense counts, you may obtain the details of them from the clerk magistrate's office prior to the hearing. This notice is to inform you that a magistrate's hearing will be held at this court to determine whether criminal proceedings will be commenced against the above named. So there's going to be a hearing. They're summoning these 9 individuals to a hearing to see if there's going to be charges put forward against them for witness intimidation. And so basically it's like a preliminary or evidentiary hearing to basically, they're still going to have to go bring a lawyer and present their side to defend themselves. So it's still a waste of time and money for them and stress that they don't need. Anyways, so notice to defendant, you may appear at this hearing to present your side of the case. You may bring witnesses with you, and you may also bring a lawyer, although it is not required that you be represented by counsel. Please bring this notice and report to the clerk magistrate's office once upon your arrival at the courthouse address. Okay, if you have any witnesses that you want to testify at the hearing, you must bring them to the hearing. Please bring this notice and report. Okay. If you fail to appear for the hearing at the date and time noted, your application may be denied. So I guess they're trying this. They want this hearing to, or who's asking for the hearing? You are hereby notified that the above complainant has filed an application. Oh, so Canton Police Department versus Deanna M. Corby. That's just garbage. Okay. So that's that. So it's the police department versus these 9 individuals in court. These are the 9 individuals the government would like to now classify as felons. Like I said, they're going to be felons after this if they get the charges to stick. Although 5 of the 9 have not received summons, it's highly likely they will be. They have no criminal record. They are productive members of society with families, including children, and the Canton Police Department are attempting to turn them into felons in order to protect the feelings of a bunch of people who conspired to cover up the unaliving of one of their fellow brothers in blue. I will remind you, a fellow officer. So they filed these charges 2 days after the people of Canton voted to audit the police department and in direct retaliation for filing a lawsuit against them in federal court. So they did file a lawsuit against the police department because of the unlawful way that the police came and intimidated them. And now are summoning them. Is that how you say it? I don't know if I'm saying it right. All right. So the kid holding the Colin Albert was in the house sign is 17 years old. So let's go back to that image. This kid right here is 17 years old. So he is a minor and they are charging him with a felony. It's ridiculous. And he's been summoned to Dedham Juvenile Court for a hearing on December 18th. The Canton Police Department is trying to lock up minors for exercising their First Amendment rights. The charges have not officially been filed yet. A clerk magistrate hearing is conducted for the purposes of deciding whether or not there is probable cause to charge a defendant with a crime. So the clerk magistrate is the one that will decide if charges are to be set forward. The bar for probable cause is much lower than guilt beyond a reasonable doubt, but they will be given the opportunity to defend themselves. I was not given the opportunity to do so, Turtle Boy wasn't, and was arrested at my home by the State Police Fugitive Unit. Their hearings appear thus far will all be conducted on January 4th. Sorry, he omitted a word there. On January 4th in front of Stoughton District Court Clerk Magistrate Lauren Green in 30-minute increments. It's in the best interest of all of these peaceful protesters to make sure the charges are not filed because the cost of litigation after that will become much more expensive. I have recommended having one attorney for all of them since the charges against all 9 will be the same. A fundraiser has been created to help with their attorney's fees, and I've been posting it in my content below, in the description below. The legal fund, the Turtle Boy account, and the Karen Reed fund also. There are no grounds for any sort of charges here. The statute that the protesters were given clearly states that whoever with the intent of interfering with, obstructing, or impeding administration of justice, or with the intent of influencing any witness in the discharge of his duty, pickets or parades in or near a building occupied by such witnesses. So, and we saw that in the last episode. This is the piece of paper that the police came to the Canton 9 with and said, here, this is the statute you're breaking. And you could be fined up to no more than $5,000 and imprisoned for not more than 1 year or both. As the protesters pointed out in the video above, there is no intent to interfere or obstruct with the administration of justice, nor was there any intent to influence a witness. Not once did any of the protesters tell Chris Albert how he needed to testify or suggest what he should do. They simply stood there with signs saying justice, free Karen Reed, free Turtle Boy, and Colin Albert was in the house. So it is because he doesn't like the message that they are sending, obviously. Chris Albert knows that his son was involved in the unaliving of John O'Keefe, and he knows that Karen Reed is completely innocent. He is weaponizing his connections to law enforcement and presenting himself as a victim in order to silence legitimate criticism of his family's roles in the unaliving of O'Keefe. Chris is not the least bit intimidated or scared of any of these people. He just doesn't like that they are pointing out the crimes committed by his family members, because it makes him feel uncomfortable. And that's exactly it, because there's nothing threatening or intimidating about any of this. Look at this. These people are smiling. They are all together for a good cause. They have signs that don't say anything bad. He just doesn't like the message that they're sending, and he doesn't want them out there. And like Turtle Boy said, he used his cop connections. It's really disgusting abuse of power. All right, so Chris sent this message to a Canton resident in August who had messaged him about his behavior. So somebody said something to him and they said grasping. And Chris Albert responded, "I'm grasping. It's 6:30 on a beautiful Saturday and you're texting me, a witness in a state murder case. I'd be careful you don't get into trouble for intimidating a witness. I will be forwarding all of your correspondence to the proper authorities. Please stop this intimidating me so I don't testify." Say what? All he said was, "You're grasping." I don't know what they were talking about before, but geez Louise. How's that intimidating? Please stop this intimidating me so I don't testify. Huh? Does that make sense to anybody? All right, so Chris had clearly been coached to say this by police because they realized that you can't charge someone with witness intimidation unless they are attempting to stop you from testifying. His brother is a Canton police detective and he is friends with Chief Rafferty. The middle-aged woman who sent him this message was not intimidating him at all. She just was expressing her dismay about an elected official's behavior. A witness in a state murder trial, I'd be careful you don't get in trouble for intimidating a witness. So what, he's going to just get anybody who says anything that he doesn't like, he's going to have him arrested for intimidating a witness, apparently. This was an ominous threat from Albert to his constituent that she should be careful if she wants to express her disapproval of his leadership, or else she could get in trouble for intimidating a witness. Considering Chris has direct contacts with the police and DA's office, this is a legitimate threat that would prevent anyone from criticizing him in the future. Yeah, no kidding. Will the police now begin charging protesters who show up to selectmen meetings with signs? Chris Albert believes he cannot be protested in any way, shape, or form, even though he's a public official, and he knows that law enforcement will do his bidding for him. Well, it seems like they do. It sure seems like they do at this point. 2 of the Canton 9 are residents of Canton and are represented by Chris Albert on the Board of Selectmen. So they have every right to say something. I mean, any of us have any right to say something, but they have more of a right because they live there. So they have every right to protest their elected officials, and those rights do not cease to exist simply because an elected official becomes a witness in a criminal case. Exactly. Attorney Mark Randazza filed a lawsuit in federal court on behalf of the protesters and asked Judge Denise Casper to issue a temporary restraining order barring the police from disrupting future peaceful protests at D&E Pizza. You can't have okay. I guess he wants his place protected from any kind of protests. So Judge Casper denied the TRO on the grounds that it was not clear that the Canton Nine faced a credible threat of prosecution. Baloney. All right, so here plaintiffs argue they face a credible threat of prosecution based on the police officer defendant's statement that plaintiffs would be arrested for witness intimidation if they protested within view or eyeshot of the witness. We all saw it. We watched it last time. It is not clear from the record whether plaintiffs have same or similar basis for injury in fact. And standing as for one example, the plaintiff in Picard, who had been arrested, but the prosecution of same was abandoned for violation of a New York law abiding people, the law prohibiting people from, among other things, holding or displaying placards or signs containing written or printed matter concerning the conduct of a trial being held in such courthouse or the character of the court or jury engaged in such trial or calling for demanding any specified action or determination. This is a really long sentence. By such court or jury in connection. Okay, well, whatever. It gets cut off. But, yeah, so they cite this other, there's just some other case law that they have cited here. But basically, they are saying that well, the judge said it's not clear from the record whether plaintiff have a similar or whatever standing. So, I don't know. She didn't believe that there was a threat of prosecution, even though they absolutely said it on the video. We heard it. All right, so she went on to claim that the Canton Nine have not shown a risk of having their right to protest being denied by Canton police, that CPD did not prohibit protests related to the Karen Reed case, and that the Canton Nine have not had their speech chilled. That's bull. They're saying they don't feel comfortable going out and protesting anymore because of what happened. So you can't say that. All right, well, whatever. All right, this makes me mad. Risk of irreparable harm. As the Supreme Court has explained, the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. I'm not even going to try to pronounce those words. Quoting Elrod versus Burns. All right, so here, however, plaintiffs have not shown a risk of irreparable harm if the injunctive relief is not granted. Although plaintiffs alleged that they have determined to not move forward with the planned protest in November in support of Reed and other similar such protests, they have provided no details regarding the planned protests and why such protests would inevitably be viewed by law enforcement as, because they've already been told that they're violating the law when they weren't doing anything, and they're making up laws saying you have to be within eyeshot, and that's not even true. So defendants are scared of going out and getting arrested, understandably so. Defendants are not alleged to have issued any prohibition or protest related to the Reed prosecution, or to have halted any peaceful, non-threatening protests regarding the Reed prosecution. They just said that they did. Moreover, it is not clear that any exercise of free speech has been chilled where plaintiffs have other public forum to express their views. That's not the point. They should be able to protest. They should be able to protest a public figure that they elected into the position. Okay. It turns out she was wrong about all of that. The Canton police were actively planning to charge the Canton Nine while claiming in court that no one was charged. As a direct result, there has been a chilling effect on anyone else who might be inclined to protest in Canton. It should be noted that I have been holding peaceful protests in front of D&E Pizza all summer, and on the two occasions the police were called, they determined that my protests were lawful. We talked about that last time. I remember watching him protesting in front of D&E, in one of them, just standing there holding signs by himself. And it's true. The cop came and he was like, yeah, there's nothing I could do. You're not doing anything wrong. He came and he left, the cop. So, sorry, my hair's all tangled. All right, so anyways, it was not until recently that they suddenly realized that actually these protests are a felony. Here's a video, a felony based off of a very unconstitutional law or statute. All right, so it was not until recently that they suddenly realized that it was a felony. Here's a video. Okay, so he provided some video of Chicken Parm Charlie. He calls him Chicken Parm Charlie. I don't know why. All right, so in another video, he was just providing his videos when he did it. So what would happen if hundreds or even thousands of people began protesting outside of D&E? How many people are the Canton police willing to turn into felons? How many innocent people will it take for the Attorney General or Governor to intervene and protect free speech rights in Canton? When will the ACLU chime in on this? Will this threat of prosecution create a further chilling effect and prevent people from protesting more moving forward? We will keep you updated on this situation as more information becomes available. So, what do you guys think about that? Let me know in the comments below. Please don't forget to like, comment, subscribe, do all those YouTube-y things. I was going to say something and now I don't remember. I always forget what I'm going to say. All right, so anyways, we're going to move on to November 30th. So just a couple days later, we find out officially that Ken Mello is the one that called the police on the protesters outside of the pizza shop. And the CPD report says protesters charged with felony for not showing ID and influencing Albert's testimony. Baloney. I don't think that they influenced testimony at all. All right, so the 9 peaceful protesters who the Canton Police Department has filed criminal complaints for felony witness intimidation and misdemeanor picketing a witness will appear in Stoughton District Court for a magistrate's hearing in January. So they said January 4th, and then there's another one for the other ones, I think, on the 18th. There was one. January 18th, they've already happened and concluded. So I'll update you when we get there. But anyway, so there was picketing a witness and the witness intimidation. A juvenile will be first to go to court on December 18th in Dedham, followed by 4 of the 9 in Stoughton on January 4th and the remaining 4 on January 18th. So here is the police report written by Officer Zeff, who twice responded to my protest outside of D&E and allowed them to continue. The individual who first called the police on the 9 protesters was none other than Special Prosecutor Ken Mello, and police claim the 17-year-old was identified with help from the Canton Police tip line. All right, so this is a copy of Officer Zeff's report. On February 5th, 2023, I, Officer Zeff, was dispatched along with Sergeant Silvassi, Officer Pasquarelli, and Officer Chin to the vicinity of D&E Pizza for a report of picketers gathering across the street. This information was called into Canton Police by the Norfolk County District Attorney's Office Special Prosecutor. Through consultation with members of Canton Police and others, it was determined that the protesters may be in violation of MGL 26813A, which states whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing a witness in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth or in or near a building or residence occupied or used by such witnesses shall be punished by a fine of imprisonment for not more than 1 year or both. And then also the fine of up to $5,000 they did not put there. So this statute was photocopied and brought to distribute to those picketing on the scene. When we arrived, Officer Chin was audio and video recording the encounter with his cruiser laptop. Okay, so that was a cruiser laptop. That was the guy that was holding the thing. I introduced myself and informed those present that we were video and audio recording the encounter. Again, that was probably to identify their faces later. I advised those present that they were in violation of Statute 13A, picketing court, judge, juror, witness, or court officer because of their proximity to D&E Pizza, which is owned and operated by Albert Christopher. Albert was present on this day at the restaurant while the protesters were picketing in front of the restaurant. Albert is currently a victim/witness in an ongoing court case out of Stoughton District Court involving Aiden Carney, also known as Turtle Boy. Number 3. I distributed the information we had prepared and was met with skepticism and disbelief of the law and their behavior pertaining to the law. Well, yeah, because they didn't break a law. You guys are weaponizing a unconstitutional statute against them. I advised them that being in this close of proximity across the street within eyesight, approximately 50 to 60 feet away, was a violation of the statute. Where does it say 50 to 60 feet away? I was asked for names of those present. No one complied. They didn't have to. I was met with disdain and contempt. Many present stated that they didn't need to give their name and refused to give their names. Well, absolutely, I wouldn't either. The crowd refused to leave when instructed to do so. No, you didn't instruct them to do so. You just told them that they were violating the stupid statute that is unconstitutional in the first place, and they weren't even doing what you say they're doing. So they continue to argue over the language of the statute. That's because the statute is for real witness intimidation and not people picketing for something that they believe in, and how it pertained to the current situation. It's because it didn't pertain to the current situation. There were several signs being held stating "Free Karen Reed, Free Turtle Boy," and Colin was in the house. Officer Chin continued to record the event and captured all vehicles present in the Walgreens lot in an attempt to ascertain the identities of those present in the future. So they followed them to their cars. They watched them. Isn't that sick? That is so sickening that they did that. It's just disgusting, that abuse of power. We're going to just sit here and wait for you to go back to your car so we can send you a summons in the mail. That's such BS, man. Officer Pasquarelli also spoke with the victim, Chris, victim, yeah, right, and will be filing a supplemental narrative. The matter continues to be investigated by the Canton Police. Officer Pasquarelli was able to identify Bradford, Corby, O'Neill, Rocco, Silva, I'm not going to say all their names. Okay, I was able to identify Braley, Robin, and Keith from prior calls with Canton Police. That's the minor, was identified with help from the Canton Police tip line. The tip line. So they must have posted his photo and said, "Help us identify this guy." That's how badly they wanted to press charges on these people. This matter will be sent to Stoughton District Court, and all offenders named will be charged with the 13A picketing and whatever witness intimidation bullshit. All right, so Judge Denise Casper denied a TRO in federal court that we've presented that would have prevented the Canton police from halting future protests in front of D&E Pizza because there was no evidence that the protesters were being banned due to the language on their signs. But that's not true because they even said it in the statement. He said it in his statement just there, and he also said it in the video. But the CPD report specifically notes that the signage refers to an ongoing criminal investigation, so clearly the language on the signs was the problem. Additionally, like the good communists they are, Canton police ran the license plates of every car parked in the Walgreens and Waterfall parking lots, as well as on the street, to see if the faces on the registration matched up with the faces of the protesters who broke no laws in refusing to give police their ID. The operation was overseen by none other than Lieutenant Michael Link, who was involved in the Karen Reed investigation. He was one of the first guys on scene, or he might have been the first one. An officer that we have frequently criticized for going inside 34 Fairview Road on the morning John O'Keefe was ended and not searching the home. So he did not search the home. All right, so this is the narrative from Officer Pasquarelli of this incident. So this is a supplemental report. On Sunday, November 5th, 2023, I was assigned the East Sector for the 7:45 a.m. to 3:45 p.m. patrol shift in fully marked cruiser CAN 686. At approximately 1:30 p.m., I was dispatched to the area of Washington Street by Bolivar Street for a report of picketers in violation of Massachusetts General Laws, Chapter 268, Section 13A. Upon my arrival with Sergeant Silvassi, Officer Zeff, and Officer Chin, we were met with approximately 10 people holding signage, so it was 9, on the sidewalk directly across the street from D&E and Pizza and Subs, located at 618 Washington Street, MA, owned by Albert Chris. Officer Chin video audio recorded the interaction using signage that individuals were holding, referenced an ongoing criminal investigation. Wouldn't it be great if like hundreds of people just showed up in front of his place? I'm not saying you guys should do this, but I'm just saying it would be great if hundreds of people just showed up right in front of D&E Pizza with signs. What are the cops going to do? They can't arrest hundreds of people if you're protesting Chris Albert specifically in his shop and you have numbers on your side. There's no way. I don't know, but I'm sure people are scared of the police now because they realize how freaking corrupt they are. All right, so anyways, the signage that individuals were holding referenced an ongoing criminal investigation involving defendant Karen Reed. Several paper copies of Massachusetts General Laws 268 Section 13A were handed out to some of the individuals involved. The picketers were explained that they could not be in view of D&E Pizza and Subs, which is not even true. Like, there's nothing in the statute saying anything about distance or anything like that. All right, so as Chris Albert was inside, who is named a witness in an ongoing open case involving Aiden Carney and while picketing, okay, for his picketing. So he's now named a witness against Aiden Carney. So they're not even saying he's a witness for the federal grand jury investigation anymore. He's a witness to the case against Aiden Carney, which isn't even true. Because wouldn't he be... I don't know if he would be a witness. A witness to what? If you're charging him for witness intimidation, how are you a witness to his witness intimidation? That makes sense, guys? I don't know. Okay, anyways. I'm probably just getting caught up in semantics, but still. Let's move on. All right, so officers asked the individuals involved in the picketing for their names due to the offense, but they refused to give that information. After we cleared the scene, Officer Chin and I, who were both in fully marked cruiser CAN 686, ran license plates of vehicles in the area, including in the nearby parking lot of Restaurant Waterfall Bar and Grill. So how many man hours did they spend running license plates, trying to match them up to the people that what's his face got on, the Officer Chin got on the video when they were standing there? How many man hours did that take for them to do that? And tax dollars wasted for something like this. All right, so Officer Chin, where was I? So he ran the plates of all these vehicles in the area. Officer Chin was able to video record using cruisers CAN 686's cruiser mounted laptop unit license plates of vehicles parked in the nearby parking lot of Walgreens, which were subsequently ran. Oh, so he videotaped all the, so they took all the, they drove around the parking lot and he video recorded all the plates. That's what they did with his big iPad that he's holding up like a boomer, and videotaping or recording all of the license plates in the area so they could go back to the office and check out all the license plates and match them versus the registrations to the people that were in that video. That's how they did it. All right, so this was done in an attempt to identify the individuals involved in order to assist the investigation so that criminal charges could be filed because those involved refused to provide officers with their identifying information for violating the law. They didn't violate a law, so get bent, all of you. Stupid Canton police officers. I'm tired of this. All right, so Officer Chin downloaded the video footage he took using the cruiser's mounted laptop unit to a USB drive and gave it to Lieutenant Link, who entered it into evidence for the case. At 13:48 hours, I ran 3 license plates that were parked near each other in the far rear side of the Waterfall Bar and Grill parking lot. These plates were blah, blah, blah. He ran a bunch of other plates, and he basically is just identifying who they were through the plates. And they're saying this one was holding the sign that stated Free Karen Reed. Rocco was identified in the video for wearing a dark colored sweatshirt. You know, that's how they went through this. That's how they identified him. What an abuse of power. So Chris Albert lied several times, including when he told police that protesters put a sign in his window and screamed at him. He lied when he said that Jenna Rocco runs everything for Total Boy in a clear attempt to suggest that I sent her there. He admitted to weaponizing his status as a witness in order to prevent people from criticizing him. But the most self-emasculating thing he said was that the 17-year-old made him feel anxious and nervous and thought it was going to ruin his business. The same business owner that has been sued almost a dozen times for not paying his bills. He also said he was fearful that they would enter the store. Okay, whatever. And so what if they did? You can get business. All right, so read... or what does that say? Okay, so this is more of Anthony Pescarelli's report, it looks like. I'm not going to read it all, but you can see that's how they identified people. Here it said Albert stated that he told her that she cannot do that because he is named a witness. So Albert also mentioned a blonde female that came close to the window and kept saying that Colin was in the house. So what? That's freedom of speech, baby. You can do that. whatever. I don't know how truthful and honest I would believe his recollection of that incident to be, Chris Albert's. No signs were ever put in the window, but when Chris Albert tells the police a lie, they blindly believe it. Never in the history of mankind has a person been given this sort of special treatment while not being able to offer anything in return except for mediocre chicken parm. Maybe he's got, like, everyone in the town has secrets and he knows everybody's secrets. I don't know. Another protester was supposedly identified by a public tip to police, and they made sure to mention that he has a FID card. In other words, they are planning to take away his guns by charging him with a felony. They are attempting to violate his First and Second Amendment rights. The police made sure to mention that the protesters were filming them and taking pictures, which indicates to me that they will be applying for a warrant to seize their phones. Nothing is illegal about filming the police in public, but nothing is off limits when you're dealing with tyrants. The report goes on to state that the protesters violated the witness intimidation statute by being within eyesight of Chris Albert, despite conceding on video that the statute doesn't have anything to do with eyesight. It says nothing about eyesight. Perhaps the most ridiculous claim in the report is that the protesters intended to influence Chris Albert's testimony and that it was more probable than not this incident had an influence on him. So more probable than not that this incident had an influence on him to change his testimony. Come on now. To top it off, the police charged them with the more serious felony violation of Section 13B because they refused to provide ID to police. Which I think is absolutely ridiculous. Somebody had a sign that said, "Have you found the Fort Edge yet?" Yeah, I'm not going to read through all of that, but you guys can if you want to. This was Turtle Boy's blog 231. Alright, so the only thing more absurd than Chris Albert being scared of these people is the idea that his testimony would be influenced by this. Chris Albert's son Colin was inside 34 Fairview Road when John O'Keefe was ended, but he claims otherwise. Ironically, he tried to get Tom Beatty to change his testimony that Colin called Tom's daughter at 12:33 and tried to change his story, but hasn't been charged for that. Interesting. The idea that Chris would change his testimony and voluntarily put his son inside his brother's house at the exact same time John O'Keefe's life was ended is so laughable that only the Canton Police Department would be so dumb enough to think about that or to believe that. Of course, they don't actually believe that. They're just weaponizing a statute to protect their close friend and boss, Selectman Chris Albert. To be clear, none of these people were required by law to hand over any sort of identification to police. At the 5:15 mark, Zeph said, "Let me grab anyone's name who wants to." He did. He did say, like, voluntarily. It wasn't you need to give me your name. He never once told them that they had to. He just said they could do so if they wanted to. So now they are being charged with felony witness intimidation for that because they allegedly obstructed a criminal investigation into a peaceful protest on a public sidewalk. At the 4:40 mark, Deanna Corby asks Officer Zeph where in the statute it says anything about being within eyesight of a witness, and Zeph conceded by saying, "You're 100% right, it doesn't say that." There's a good chance the magistrate will find probable cause because courts have a tendency to rubber stamp and blindly believe anything that police tell them, because we live in a society where we trust police and assume that they are honest brokers, but they aren't. Not all of them. That is clearly not the case in Canton, especially small towns. There's a lot of problems in small towns because there's not anybody holding them accountable. So it's clear it's not the case in Canton, but it would take a very ballsy magistrate to stand up to the police. Helena Rafferty, who is the driving force behind these charges, is well aware that none of these people will ever be convicted. But the point isn't to convict them, it's to drain them of their time and money in order to create a chilling effect that should scare others from protesting in the future. They are clearly trying to make sure that these people lose their jobs and access to firearms. They are violating both the First and Second Amendment rights and are hoping that the protesters will agree to stop protesting in order to have the charges dropped. So that's what this is all about, protecting the people who took the life of John O'Keefe so that they don't receive any criticism or any commentary that they don't approve of or like. So it's cops protecting cops, cop enders. Yeah, basically. This is actually good news. So in December 18th, the clerk of court, or the clerk magistrate, actually saw the juvenile, the one that was the underage juvenile of the Canton 9, and his charges were dismissed. So let's look at that. So 3 weeks ago, the Canton Police Department filed a criminal complaint against a 17-year-old, attempting to charge him with violating Chapter 268, Section 13A, picketing a witness, and Chapter 268, Section 13B, felony witness intimidation. The juvenile's alleged crime was peacefully protesting outside of D&E, which Selectman Chris Albert said made him feel scared and intimidated, and which the police claim was likely to affect Albert's testimony. Give me a break. In the Karen Reed case, his son read Colin Albert was in the house, which Colin's aunt Jill Daniels admitted when she came. I should say his sign, I bet, not his son. All right. His sign said Colin Albert was in the house. So Jill Daniels, is Colin's aunt, is actually the one who admitted that Colin was in the house at the time that John showed up, because she said it in the grand jury testimony. All right, so there's the juvenile here. Colin was in the house. Colin Albert was in the house is simply a statement of fact, not a politically motivated sign. The sign had no intention of changing Chris Albert's testimony or intimidating him in any way. Today, the juvenile had a hearing before a clerk magistrate in Dedham who would decide, remember this is December 18th, who would decide if there was probable cause to move forward with criminal charges. Although the bar for probable cause is extremely low, the magistrate found that there was no probable cause for violation of 13B, and that although there was probable cause for 13A, the clerk elected to dismiss it altogether. I don't know. Timmy is a senior at Tewksbury? No idea. High school, and was threatened with suspension by school administrators. It's completely inappropriate for the school to have done this for several reasons. 1, he wasn't charged of a crime. 2, he wasn't convicted of crime. 3, kids who are charged and or with crimes still have a right to attend school. I taught in Worcester for 2 years. Kids regularly miss school for 2 to 3 weeks at a time to go to lockup before returning to class. And 4, the magistrate's hearing was not public record, so the school would have no way of knowing for sure that a criminal complaint had been filed by CPD because he was a minor. So, what Helena Rafferty and the Canton Police Department attempted to do to this young man is criminal in and of itself. She tried to ruin a life of a minor because he peacefully protested outside of Chris Albert's restaurant on a public sidewalk. This was the entirety of their interaction. Yeah, and in which Albert was clearly the aggressor. Oh, because remember, he filmed them and said, "Oh, you're protesting a witness, huh? You must be proud of yourself." Trying to get a minor charged with a crime because he made you feel uncomfortable. Chris must be proud of himself. Too bad it failed, much like his business, his parenting, and his ability to please women. Damn. Shots fired, Turtle Boy. Okay, so just a reminder, when Chris's son Colin was 17, he was inside a house where a Boston police officer was beaten unconscious and dragged outside to where his life was ended in the snow on that cold night by hypothermia and the brutality of his injuries. So his son Colin is a sociopath. This is Turtle Boy speaking, not me, who regularly posts videos on social media threatening to end other high school kids. Yeah, that's not right. You can't be going around threatening to end other high school kids. And he has the gall to lecture other 17-year-olds about how they shouldn't be proud of their behavior. I would take Timmy any day of the week over Colin. Timmy is civically engaged and standing up for something righteous. Timmy, the protester. He wants justice for John O'Keefe and Karen Reed, and he's brave enough to confront the man whose brother and son were present in the house when O'Keefe was ended. Timmy should be proud, and so should his parents. Chris should be ashamed, but he's not because he has no shame. The fact that Chief Rafferty is this ignorant when it comes to understanding how our law works speaks volume about her incompetence and lack of leadership. The bar for probable cause is extremely low, and the criminal complaint that she ordered to be written couldn't even make it past the clerk magistrate. This is exactly why CPD needs to be audited. The police department, which they all voted as a town to audit the police department because they all know that there's some shady stuff going on there. So the magistrate did find probable cause for a 13A picketing a witness, but the fact that the magistrate dismissed it shows that he realized that it was morally wrong to charge a kid with a crime for peacefully protesting. What kind of message would that send to other civically engaged youth? That was a direct shot at Helena Rafferty, as the magistrate clearly viewed her as cold and evil. Timmy's attorney, Bill Jens, is also representing 6 of the other Canton 9 who have hearings on the 4th and the 18th. It's unclear if this will have any effect on their cases, as every magistrate is different and they will have their feelings in Stoughton. They were held their hearings in Stoughton, so not even the same district. But it doesn't matter, because at the end of the day, they're going to win. I'm going to win, and Karen Reed is going to win. It's just a matter of time. I would be honored to have Timmy as a guest on the live show tomorrow night if he's interested. And actually, I do believe Timmy did come on the show and talk about his experiences. And finally, this is Turtle Boy's last coverage of all of the Karen Reed movement before he got arrested, pretty much. So December 19th, he wrote this blog post: hundreds show up in Canton to protest police weaponization of witness intimidation statute. Mainstream media completely misses the point. So this is going to be our last article, and then I'll give you just kind of a brief update on where we are. All right, so on Sunday, at least 250 to 300 people showed up in Canton, this was back in December, for a protest at the police station, which was peaceful as usual. The protesters were not just there for Karen Reed this time. They were to protest on behalf of the Canton 9 and Turtle Boy, who have been targeted by the Canton Police Department and had the witness intimidation statute weaponized against them in order to silence their First Amendment rights. And look at all those people that show up. Like, this makes me so proud to be an American sometimes when I see people standing up for what they believe. It's a lot of people. All right, so scroll through here. Supporters of women accused of Braintree Native protest outside police station. This is the best description of the event the mainstream media could come up with. Supporters of woman accused of ending Braintree Native protest outside police station. Really? Like, I would never think that this was the Karen Read case. Whoops, I just changed pages on us. I would never think that that was Karen Read, because it has nothing to do, it doesn't say Canton, it doesn't say Boston police officer, doesn't say John O'Keefe's name, nothing. So this is the best description of the event that the mainstream media could come up with. They make it sound like we were all there to support some life ender who ended some random guy in Braintree, except we were there specifically to protest the suppression of First Amendment rights in that town. At no point in their 4-paragraph story, whoever wrote this article, do they mention that. So here's the article from the Patriot Ledger that he grabbed. Yeah, it doesn't even give much, I don't know. It's just crazy that the mainstream media is not reporting on the fact that our First Amendment rights are at stake in cases like this and Turtle Boys and Canton 9. All right, so imagine if we had to rely on useless institutions like this for our news. It's scary. That's why you guys come to YouTube, right? Because the mainstream media news isn't getting it right. So you got to find your news somewhere else. That's why I turn to it. Anyway, so it's scary to think about what the public wouldn't know about. Luckily, the internet allows anyone who's willing to put the effort in to find out more details and report the truth. The young jerks were at the protest and documented the whole thing. Our presence in Canton was a big FU to the people who think they can silence us. We stood directly across the street from Tim Albert's house with the filled-in pool, and I made sure to have my measuring tape with me to make sure that the McAlberts stayed at least 100 feet away from me at all times. I know they get really scared and sad when I get too close to them, so I wanted to respect their safe space. That's funny, because he's not going to do anything to them. But it's really humbling to see all these fine people who show up to support Karen Read, myself, and the Canton 9. It's so encouraging to see the crowds, I agree, at these events, because it's a reminder that our following isn't just online, and turtle riders aren't going to back down in the face of suppression. It was great meeting so many of you, especially all the kids attending their first protest, and I hope to see more of you, unfortunately, at the January 5th hearing in Dedham. He was in prison at that time and he could not attend. However, it was probably the biggest protest that Karen's had so far, and bigger than Turtle Boys, bigger than any other that Karen has had. So it was a large event. Many people out on the streets speaking their mind. So he says thank you to Paul Cristoforo, Dana Leonard, and Tracy Murray for organizing the uplifting event. See, they are the ones that are organizing these protests, and yet Turtle Boys charge for protests. I don't get it. That's cute. Some more people protesting. This is, I believe, just more images. I think the article's over. Just images from the event. It was a nice peaceful protest, and it went off well, but then, as you know, right on Christmas Day or Christmas Eve, right around Christmas Eve and Christmas Day, Turtle Boy was having his own problems with an ex-girlfriend, and that's a pretty dog. And he ended up, what I believe to be set up by the ex-girlfriend, and that's why he's sitting in prison right now. I love that picture of Rita, by the way. That is Rita Lombardi. She's a Canton native, and she is outspoken about this case, and she could be a great leader if she wanted to be, if she wanted to take on that role for the town. And she said, like, she never cared about politics or anything until this case, and she started seeing the injustices going on. So anyways, I hope they find that Ford Edge that was outside Fairview Road. He's got his tape measure. He really did. He really did bring his tape measure, so he stayed away from the witnesses. That was so smart of him. All right, so how many more pictures we got? A lot more. I don't think so. So what do you guys think of this case, the Canton 9? Let me know in the comments below. Do you think Turtle Boy should have been locked up? Do you think Turtle Boy was set up by the ex-girlfriend? What do you think about the Canton 9? Is it unfair that they have to go to court and fight this now? I think it is. I think it's a real misuse of their power. It's very disturbing to me that this is happening in our modern day society right now, where cops are corrupt and trying to frame innocent people and putting their journalists who have something negative to say about them, putting them directly in jail just because you don't like what they're saying. I can't believe this is happening, and it's still going on before our eyes. So I'm just baffled still that just the balls that the people in the Norfolk District Attorney's Office have, just the balls to do some of the things that they're doing to Turtle Boy, to Karen Reed, to the Canton 9, to all of them. Let me know what you guys think. At this point, oh yeah, I wanted to update you on the last two hearings. So the January 5th and the January 18th hearings. The magistrate has heard both sides now. They really put forward, the Canton 9 put forward a strong argument that everything should be thrown out because the Constitution, the statute itself is unconstitutional, and they didn't prove any intent, and yada yada yada. You know, they laid out a good case as to why now they are wanting reparations for being falsely intimidated, for going to prison, being prosecuted. So anyways, they put together their case, and I only got like snippets of the attorney telling us, or updating after, during the breaks, what was going on when Tom CPU was streaming the Canton hearings live. So I did listen to the hearings, or his streams, and listen to the feedback from the attorneys. Basically, the magistrate is taking it all under advisement, and hopefully, I think he said within a month or so, we should have some kind of an answer. And I don't know if that was a month from January 5th, or I think it was January 18th. So hopefully soon we might be hearing an answer about Canton 9, if we haven't already, because at this point I haven't heard anything about the Canton 9. So I'm continually, trying to keep updated on that. So if I hear anything on that, I will update you guys and let you know. I'll also update you on Aiden whenever I can, if there's any new updates. In the last episode, I did tell you that he's he is set to do no more than 2 more weeks. He should be out by the 23rd, if not sooner. And he does have a hearing this Friday with the judge to determine whether he can walk out of jail or not. And they did revoke the 90-day bail, so he only has to do 60 days. So that I reported in the last episode on the the Canton 9, sorry. So anyways, that's that for this. We are for the most part caught up, and I will just let you know updates as we go along in this case. Thank you so much for going along the ride with me, the journey, the ups and downs, the the getting angry at certain individuals in this case. So thank you. I know, there's lots of people you can watch on YouTube, so I really appreciate you watching me, and I hope that I will see you next time. Thank you so much. Don't forget to like, comment, and subscribe. I will see you later. Bye.